2-part series, which you can view on YouTube, the City of Springfield YouTube's channel. And these are also part of a tenant education seminar that some of us at the Springfield Clark County Fair Housing Advocates developed several years ago, and we've been offering them in the community. In fact, we had one scheduled for late March of this year, and we had to cancel it because of the COVID. And so we're really happy to bring it to you today. We want to thank Val Lowe with the City of Springfield for administrating the program today. We did have our first program yesterday on tenant housekeeping tips, resources, and stress management with James Wallace, which, like I said, you can view that on the city's YouTube training. We also will have 2 seminars next week. One will be with Rachel Klopfer, who was with the Consumer Credit Counseling Service. She will be talking about personal finance management, and then understanding your credit on Tuesday, June 2nd from 4 to 5. And then I will tell you about fair housing mediation and city services on Wednesday, June 3rd from 4 to 5. But today, our topic is landlord-tenant law with Frank Catazarit. Frank is the senior managing attorney of the Legal Aid of Western Ohio Springfield office, which serves 5 counties. He's very knowledgeable about landlord-tenant cases. He's been representing tenants in Springfield for actually 34 years with the Legal Aid of Western Ohio. And when I have a question, I always call Frank, and he knows the answer. He's been active also with the Springfield Clark County Fair Housing Advocates for over 30 years and has been always very helpful in all of our work to try to educate people in the community about fair housing and landlord-tenant issues. He and his wife have raised 5 sons in Springfield. He's also, I know, a talented soccer coach, and he has many other skills too. But I really just appreciate him because he's always somebody I can count on, and he will answer my questions. And I'm sure he'll answer your questions too. He'll be giving a short presentation at the end. If you have some questions, you can unmute yourself and ask them. So at this time, I'd ask you all to mute yourselves, and Frank will share his presentation with us. So thank you so much, Frank, for preparing and for being here today and for being an important part of our community.
Well, thank you, Nancy. I appreciate those kind words. And yeah, I hope I have answers for everybody. These are kind of strange times, as everybody knows. Evictions were put on hold in Clark County for about 2 months. They started up again as of last week. And I fully expect the next couple of months, we're going to see a lot of clients or a lot of tenants who are facing non-payment evictions because of loss of job, loss of employment due to COVID-19. And those are issues that we are hopefully trying to address or will address if and when they come up. And also the CARES Act, which I'm not 100% knowledgeable on that, but the CARES Act also provides some guidance with regards to subsidized housing, public housing type cases. Next slide, please. And the next one. Okay, so the presentation this afternoon is going to be just a real basic presentation on landlord and tenant law. As Nancy said, I've been doing evictions for a long time, but it seems like new things always come up, new questions always come up that I haven't seen. We attempt to help tenants who are being evicted. Not always works, but one good thing about this landlord tenant or this tenant education series that we have is hopefully folks will view these both landlord and tenants and get a better understanding of the rights that each might have. So the first question would be in this presentation, do you want to rent or buy? Now, obviously, most people would say we prefer to buy, especially given the housing stock in Springfield, the poor housing stock. I think everybody is aware of that. But if you're going to either rent or buy, you want to make sure your credit is good. Do you have credit cards? Do you have a cell phone? Do you need a cosigner to be able to rent a place? Next slide, please. So if you want to rent, I mean, what you want to do is make sure that the place is worth renting. In other words, look at it. I've seen any number of tenants who've come to us and said, well, we've never saw the place before we moved into it. But you want to make sure things work. You don't want to get into a situation where you have problems with the water pressure, no hot water, the electric doesn't work or half the sockets don't work. Furnace works is also a big one. Not this time of year, but AC is, air conditioning for sure. But you want to look at a place before you actually rent it. Next, please. All right, so if you're looking to rent a place, you really don't want to pay more than 30% of your income, maybe even a little bit less than that. And you need to take into account what it's going to cost for utilities. If there are repairs that need to be made, you want to ask the landlord in advance to make those repairs and make sure you put it in writing so there's no discrepancy later on that you made this request. The other thing about putting a repair list in writing is you want to make sure that at the end of the case or at the end of your tenancy, that they're really, again, if the landlord's claiming you damaged this or that, you're going to have something in writing that says, hey, this is the way it was when we moved in. You're going to want to check to see if it's a good neighborhood. Application fees are generally not refundable, but that's something you also want to ask before you rent a property. Next, please. Okay, so we already talked about this. It talks about in there, important to document any conditions. A lease can be either written or oral. Written lease is generally what is called a fixed term lease, which could be like a 6-month or a 1-year term. An oral lease is generally month to month, which means it renews every 30 days that you pay rent. Make sure you're aware of how much the rent is. Obviously, that's a big factor. Make sure you know when it's due. Some landlords will offer a grace period before a late fee is imposed. Some landlords will not. They want the rent by the 1st. And make sure you have emergency contact information for the landlord. Next, please. Okay, so we do have some questions and answers for you. And if you know the answer, if you want to unmute yourself, so be it. If not, I'll just go through this. So the first question is, the apartment's cheap, but it's rented as is. Is this legal? Is it legal to do that? So you've got choices. And is it a contract where you have to make all the repairs? Is it an enforceable contract, or is it a legal contract? Or is it a contract that the landlord still has to make the repairs? And if somebody wants to answer, that's fine. If not, that's fine too. I'll give you like 10 seconds to consider it before we go to the next slide.
I really guess the landlord still has to make repairs. C.
You can go to the next slide, Nancy. Yeah, that would be correct. The landlord has to provide, under Ohio's landlord-tenant law, a habitable unit. It's also the landlord's responsibility to make repairs to the unit. And I've seen, again, any number of leases which say that the tenant's going to be responsible for repairs. That's going to be, if it ever goes to court, I certainly would argue that's not enforceable. That's not an enforceable clause in a lease. Next slide, please. Okay, next question. What's a security deposit? Everybody knows what a security deposit is, right? You've all rented, you've all paid security deposit. So there's 3 choices again. Is it something that goes towards your first month's rent? Is it something used for the last month's rent? or is it used to cover any damages that the tenant may cause?
I would guess C again. It can be
Okay,
used to
yeah, I
cover.
have a lot of C's, I think, in these. But yeah, the next slide, Nancy. Yep, you are correct again. Security deposit definitely used to cover any damages that you may cause while you're a resident, or it can be used to pay for any rent that might be due when you leave. Next slide, please. Okay, paying rent seems pretty simple, right? Again, in crazy times like we have now, tenants may not find it so easy to pay rent. I know there are certain programs, again, that might help with rental assistance, but you've got to pay your rent. And you want to get receipts when you pay your rent. If you have a checking account, best way is to pay rent by check. That way you'll get a canceled check showing that the rent was accepted and cashed by the landlord. Money order would be the next best thing. Not as good as a checking account, but a money order would do. And basically you've got your money order receipt to show that rent was paid in case there's any discrepancy later on down the road.
Frank, I keep running into tenants who say their landlords refuse to give them receipts. Is that okay?
Landlords can certainly refuse to give receipts, and if that's going to be the case, then you don't want to pay with anything. You don't want to pay with cash, that's for sure. You can, again, use a canceled check. You can use a money order receipt as evidence that you paid rent. But you can also, as the tenant, and I'm not saying the landlord's going to do this either, but as a tenant, you can also say, well, I've got a little piece of paper, landlord, why don't you sign it that says I paid rent for the month of May 2020. And that would be good enough. All you have to do is get the landlord to sign off on something like that. I would guess that most reputable landlords are going to give receipts because landlords keep records too. And they're going to want to have a record of it. Now, any public housing, subsidized housing, Section 8 housing, they're going to have track records of when rent was paid. Sometimes they are reluctant, those landlords or apartment managers are reluctant to give receipts, but normally they track it on their computer system. And again, the second point of this, if you have a written lease, the amount of your rent cannot be changed until the lease expires. And to just expand on that a bit further, written fixed term lease. In other words, if your rent is $300 a month for the next 6 months or for the next year, your rent cannot be increased for that term. If you have an oral lease, 30 days is all that's required for a landlord to give you notice of a rent increase. Next slide. Okay, now, how do you get your landlord to make repairs? Well, some landlords are never going to make repairs, and I've certainly seen some of those. But do you give the landlord a written notice listing all the repairs that are needed? Do you withhold rent until all repairs are made? Do you contact the city's housing inspector? Do you deposit your rent with the court? Do you make repairs and deduct it from your rent? Next slide, please. All right. Landlord-tenant law in Ohio specifies that you must provide your landlord with a list of repairs that need to be made. So you prepare a list, you give to the landlord, you want to keep a copy of that list. You want to put a date on it so you know exactly when you gave this to the landlord. You can also contact the housing inspection services, and I know Nancy is going to talk about that in her presentation, how housing inspection works. And then if the landlord does not make the repairs within a certain amount of time, you can pay the rent to the court. It's what they call rent escrow. The reasonable time kind of depends on what repairs need to be made. If it's, say, a non-emergency repair, 30 days is going to be considered to be reasonable for a landlord to make repairs. If it's something emergent that needs to be done right away, like a furnace goes out in the winter, a broken window, something like that is probably going to take less time, maybe 24 hours for the landlord to make the repair. Now, again, reasonable is subject to, anybody's interpretation, but that's just that's the end result of hopefully the landlord making repairs. Next slide, please. Okay, we hear this quite a bit from tenants. Can a landlord keep coming into someone's apartment? And, people think because the landlord owns the place, that yes, they can come in. Not true. So you've got 5 choices here. And I'm going to say 2 of them are correct. I'm going to guess. I've never seen this presentation before, so I'm going to guess C and D. Okay, I got one right. Yeah, if it is an emergency, a landlord can certainly come into the property. And usually the emergency is because the tenant might have called them or a neighbor might have called the landlord, and also with a 24-hour notice. Any other time the landlord is not supposed to come in, and a tenant can certainly tell the landlord, you can come in, but you got to give me 24 hours notice. I'm not going to let you in right now. Will tenants do that? Will tenants say, landlord, you got to leave? Don't know, but that's the way, that's the protection that the tenant has in this circumstance.
So Frank, sometimes I have tenants call me, or landlords usually call me and tell me that, the tenant has complained about repairs that need to be made. And then the repair person shows up and the tenant said, you can't come in. And so then the tenant will keep complaining the repairs haven't made, and the landlord will complain to me, well, how can I repair things if the tenant doesn't let me in when I send the repairman? I can't always control when the repairman can get there. So what would you say about that situation?
Yeah, and that's a good question. I mean, we've seen that too, Nancy, quite a bit. And like you said, if the landlord is trying to get the repairs made, and is, I'm sure, frustrated because they can't do it. If I was a landlord, I would just document the times that we sent the repair person out there and could not get in. It happens a lot. Where we see a lot of, especially in public housing, would be in like if an exterminator is supposed to come in and say spray for bugs, and the tenant won't let the exterminator in. And the only thing I can say to a landlord is, just document it. And, because at some point, if the tenant's not cooperating, you're probably going to want to evict that tenant. So documentation would be the best way for a landlord to do that. Okay, we've got A through K. For what following reasons can you be evicted? This seems to be on its face an easy question. Next slide, please. Yeah, it definitely can be evicted for loud noise, cleanliness damaging. Under those circumstances, though, what a landlord is supposed to do, and this again comes from Ohio's landlord-tenant law, landlords are supposed to give a 30-day written notice with a right for the tenant to cure the problem. In other words, if the tenant is noisy, is loud, damages the property, is unsanitary, and the landlord says, tenant, I want you out of here, but I'm going to give you 30 days to clean up your act. And at the end of that 30 days, if there have been no further problems, theoretically or technically, the landlord has lost the right to evict because the tenant was given the notice to cure and the tenant did cure any of those problems. Non-payment of rent, pets, unauthorized tenants certainly are grounds for eviction. Non-payment of rent being the biggest one that we ever see. The pets issue also comes up with, sometimes, and I'm sure some people have seen this, some landlords have seen this, where the tenant has a service animal or emotional support animal, which could be an exception to a no pet policy. But if you move a pet in under a no pet policy, generally speaking, right, you're going to be evicted for having a pet. Unauthorized tenants comes up fairly often as well, where you move people in who are not on the lease. Again, all reasons for eviction. And under these circumstances, the landlord is supposed to give a 3 days. I mean, landlords who view this video are going to know this. That a 3-day notice is the prerequisite. It's the beginning of an eviction process. So you give the you give the tenant a 3-day notice. And then if the tenant is not out within those 3 days, then the eviction process continues. Race, religion, and so forth are not grounds for an eviction. Those are all protected classes under federal, state law. And again, Nancy will talk more about those during her presentation.
Frank, there is a question from Lauren. She wants to know how long must a landlord give a tenant to remedy non-payment of rent?
There is no real set time. It's going to be up to the landlord and the tenant. We've, not me personally, but our agency has trying to work on what's called pay to stay. Is anybody familiar with what pay to stay means? No?
Well, maybe it gives you a chance to get caught up on your rent, maybe?
Yes, that's the basic principle of it. And obviously there is no legislation governing pay to stay. It would have to come either from the state legislature if you want to amend Ohio landlord tenant law, or it could come from certain cities if they want to pass legislation within the city limits regarding pay to stay. And that's the purpose of it, to try to get the tenant to catch up. And if you carry it to its extreme, the tenant would have until like the day of an actual eviction to catch up on rent. That would be like the ultimate pay to stay.
I've heard that suggested during this time of COVID-19 that landlords might consider doing that, because a lot of times tenants are out of work for not their own fault. But certainly it's not something that's required, but it's been suggested. I've heard people suggest that.
Yeah, and I understand. I mean, I do understand that landlords need to get paid too. I mean, that's never been an issue, because landlords have to pay bills, landlords have to pay mortgages, and I know we do have a lot of sympathetic landlords here in Springfield that are willing to work with tenants. I've run into a number of them, but at some point, you reach that, well, I really got to pay my bills, and I've carried you for 6 months without paying rent. We're going to get rid of you. I had one last week. I had an eviction last week that, the landlord was up there actually crying on the witness stand saying, I really don't want to evict this person. I've known him a long time, but we have no choice. Whether that was an act or not, I don't know. I mean, the landlord might have been sincere about it, but even so, I think In this particular instance, the tenant had not paid for probably about 10 months. But I don't know if I answered Lauren's question or not, but it really is going to be up to the landlord as far as how long they can have to pay back the rent or pay on the rent. And again, if you've got a written lease that gives you a grace period, you're really talking about maybe you have until the 5th of the month to pay the rent. And if not, we're going to start the eviction process. With regards to the what happens after an eviction is filed, landlord can still, again, agree to accept the rent. But a lot of landlords are going to want the tenant to pay court cost as well, besides the back rent. Next slide. I'm not sure how much more time we have left, Nancy, or how many more slides we have here, but we'll see.
We're fine. We actually have until 5, but we said this, they would last till 4:30.
Okay.
You're fine. But it seems like the screen is frozen, so I'm gonna have to, not sure why. I might have to stop the share for a minute and come back. It just tends to get something. Okay, is this the next one?
Yes.
Okay, sorry, apologize for that.
It's technology, Nancy. What do we expect? We always expect the best. Sometimes we don't get that. I don't know if I have in this presentation how the eviction process works. And again, I know every landlord is going to know how it works, but maybe not every tenant. We've talked about giving a 30-day notice, then giving a 3-day notice, and then an eviction complaint is filed with the court. Normally, when an eviction complaint is filed, a hearing is going to be held about 3 weeks down the road. But right now, again, with COVID, evictions have been pushed back for a couple of months. So if you're going to file an eviction, say right now, you're looking at maybe being July before you get into court for a hearing. And in the meantime, again, I know I do sympathize with landlords that you're going to be out rent for a couple of months where normally you would be in court in about 3 weeks. But again, just the way the times are right now. Subsidized housing, which I really don't have in this presentation, but if we have time, I can just briefly talk about that. But with subsidized housing, things are a little bit different. It depends on the type of housing it is, and when I say subsidized housing, I mean things like public housing, Section 8 housing, any number of other programs that provide a subsidy for a tenant to live in a certain property. And with that case, or in those cases rather, there are additional protections for the tenant. It can't just be a 3-day notice and you're out. It's got to be either a 10 or a 14-day notice, depending on the type of subsidized program it is. The landlord has to give that notice in writing. There has to be a time for the landlord and tenant to talk about the problem, see if it can be resolved. And then you're talking about an eviction being filed after that. So the tenant does have some additional protections under, or if it's subsidized housing involved. So that's just a brief, I mean, I've got a whole PowerPoint just on that, but that's just a brief summary. The next slide we've got is, so you're wanting to move, you want to make sure that you give the proper notice. Again, if you're in a fixed term lease for 6 months or a year or something like that, if you leave before the time is up, you're basically violating the contract or breaking the lease. And you can be held, you as a tenant can be held responsible for the remaining lease term. Now, the landlord has to try to re-rent the property, but if the landlord cannot re-rent it, the tenant can be held responsible for the remainder of the lease. You do, as a tenant, need to clean the place when you leave. I know a lot of landlords complain about that with reason. I've seen, again, conditions of properties through pictures, videos, what have you, of the shape that a tenant can leave property in. And it's not, not pretty for the most part. As a tenant, you can protect yourself. We talked earlier about documenting the repairs that need to be made up front, but you can also document the things that are like maybe not in the best of shape, like, hey, the carpet wasn't shampooed before I moved in, or this mark was on the wall before I moved in. As a tenant, you want to document that at the beginning, and when you leave at the end, document anything. A lot of people nowadays with cell phones, they just go through the house, apartment, and video it. So they've got evidence in case the landlord says, well, you damaged this, you damaged that. The landlord files something in court to collect damages. The tenant can go in and say, look, I've got the video. These things were pre-existing, were there before I moved in, or here's the place now. Here's the condition that I've left it in. You got to return your keys to the landlord when you leave. And, it seems to me that there was a city ordinance, and maybe I'm wrong, but I thought there was a city ordinance that says every time a new tenant moves in, the landlord's supposed to change the locks. I remember hearing about that sometime like 30 years ago, but I don't know if that's in effect or not. But you as a tenant clearly want to turn the keys back in, because if you don't turn the keys back in, the landlord's going to say, well, you might have left the place, but we can't rent it because you still have the keys, and we're going to charge you for rent for an additional month or two or whatever until we get the keys back. Make sure you turn off. I have here, make sure your phone is turned off. Well, nobody has a landline anymore, so we can kind of cross that out, but make sure your utilities are turned off. And if you want to get a security deposit back, you've got to give your landlord a new address in writing. Otherwise, the landlord ain't going to know where to send the deposit to. Next slide, please. Okay, just a real brief summary about how our office operates. We are legal aid, which means we accept folks who are low income, and they've got to go through an application process to determine if the person is eligible for our services. And there's two ways to contact our office. Actually, three ways, except the third one doesn't really apply right now. The applicants go through what's called the legal aid line, and you can access the legal aid line either by the toll-free number that's listed there, or you can do an online application. For tenants who live within, Clark County, you can also come directly to our office to apply, except we're not open right now because of COVID. But once we're open up again, I have no idea when that'll be, we can encourage tenants to come directly to our office to make the application. Next slide, please. Okay, for those who don't know, our office is located at the Commerce Point building, which is 20 South Limestone Street. We're up on the second floor, Suite 220. And I don't want to encourage people to call me directly unless you're a client of our office already. And if you email me, and if you're not a client, chances are I'm not going to reply to you anyway. But that is the contact information for our office. Next slide. Questions and answers. So, I know that was a real quick jaunt through Ohio landlord tenant law. Just basic stuff. I know Nancy has brochures that cover the same information. Our office has brochures that cover the same information. But we do encourage tenants to apply with our office before the eviction is filed. You know, we've seen tenants, I've had tenants or potential applicants, I should say, call the day before a hearing and say, hey, we need help. I've had tenants call the day after the hearing and they've been evicted and they say, hey, can you help? No, we want to get, you know, as much information as early as possible to be able to prepare for a case and to frankly determine whether there's any reason we should accept the case. And we're going to accept cases if there are valid defenses to raise to an eviction. Okay, questions?
You're welcome to unmute yourself if you have a question, and go ahead and just unmute yourself and ask your question.
I know Lauren has more questions. She always does.
I see Teresa's unmuting herself. She must have one.
All right.
I knew that was coming, Frank.
Yeah. I can always count on you for questions, Lauren. I hope I have an answer. So what's up?
I do have a couple of questions. One, can I get the slide presentation sent to me? And two, when is the next training that you're doing on subsidized housing?
I don't think there's any currently scheduled to do that. I know we had talked with Laura over at Project Women there about doing something, but because of what's going on with COVID, we kind of put all those things on hold. But we had talked, Laura and I had talked about doing one of those.
If you want to, if you want to do it in this format, we could set up another session later if you'd like to do that.
Yeah, that'd be fine.
I
And
would love that. This is super easy and it's very convenient. And I think you did a great job, Frank. It was a great presentation.
So this will also be up on the city YouTube channel, so you can, refer people to it so they can listen and learn. So we think that'll be a great resource for people.
And I can email the PowerPoint to you, Lauren. I just made a note so I don't forget, but I can email that to you. So I know we did the presentation to Project Women about the Violence Against Women's Act. And that's kind of one of the exceptions right now under the CARES Act. And I know Nancy probably knows a lot more about that than I do. I know when Nancy and I have emailed about the CARES Act, she knew a lot more about it than I did. Although I've got a cheat sheet here sitting on my desk.
Yeah, yesterday we had James Wallace with Interfaith Hospitality Network on, and there is some funding right now for tenants that may be in have financial problems to try to avoid eviction. So you can refer people to Job and Family Services if they have children, or to Interfaith Hospitality Network if they don't. So there is some funding there. Teresa, did you have a question?
I do. Regarding Section 8 housing, we understand that if we need to evict a tenant with Section 8, that we need to give them a 30-day notice and then a 3-day notice before we can file in court. Frank said something about a 10-day and a 14-day before we can file in court. Just wondering what the regulations are on that.
Good question, Teresa. There's different programs have different responsibilities. And say, when I was talking about either a 10 or a 14-day notice, that really applies to public housing. And I know you don't have any public housing units.
Right.
But it also applies to, say, the Public Housing Authority, Springfield Metropolitan Housing in our community, where they might have certain units that not only public housing, but also Section 8 housing. The same regulations are not going to apply to a private landlord with Section 8 tenants.
So what is the regulation as far as filing, posting for an eviction?
Well, it should say, and you should have a copy of the housing assistance payments contract.
We don't, I don't think.
No?
No.
Then my guess would be, and I'm just guessing, my guess would be what you just said, a 30-day notice and then a 3-day notice.
Okay.
Because certain, and again, with certain programs like we talked about, the public housing and so forth, there is a requirement under a Department of Housing and Urban Development, certain requirements that a public housing authority has to follow in order to evict a tenant. And that's a bit more complicated than just say, okay, I'm going to give you a 30-day or a 3-day notice.
And I would think that Metropolitan Housing would be happy to answer that question. If you have trouble, I'll be glad to help you with that. If somebody
I'd like an answer to that, Nancy.
like, if you could just email it to me specifically, I will
Sure.
send it to the Housing Choice Voucher Coordinator, and I'm sure she'll get back to us.
And is that Sean?
Sean is one of the people, but then there's somebody above her. There are a
Okay.
couple administrators above her.
Okay, I will. I'll send that to you.
Okay.
Yes, Sean usually answers my questions, Teresa, when I've got them.
Okay.
But sometimes now she's been referring me to her supervisor.
Okay. Okay.
But again, it does operate differently. If you're a private landlord who rents, under the Section 8 or the Housing Choice Voucher Program.
Well, some landlords, as you probably know, are getting rid of their Section 8 because of the requirements to do Section 8. A lot of things that are required before you can rent Section 8 that are what we sometimes think are nitpicky, that have to be done. And we feel like, we have decent rentals, and then they come in and nitpick something. So John's usually pretty fair, so.
Yeah, I've seen that too, Teresa. And I don't know that there's a happy medium. And I do know that there's a lot of landlords, getting out of that business, which is, not good for Springfield. But
correct, it is not good for Springfield.
yeah. But again, I also know that there's a lot of really old housing here in Springfield that is never gonna, that is never gonna be brought up to what certain people think is code or what have you.
Correct.
Yeah.
Thanks, and I'll send that to Nancy so that she can try to get a better answer for us. We have checked with our attorney, who can't give us the answer to that as well.
It may be in the subsidized housing presentation that we have. I'll take a look at that too, Teresa. And if I find something there, I'll let Nancy know
Thanks.
about it. Sure. Any other questions?
Well, maybe we're finished then for today. And we want to thank Frank again for taking his time to prepare this and to speak. And we'll invite you back next Tuesday at 4 o'clock. And you're also, some of you are landlords, we encourage you to invite your tenants. Like the first session will be about how to do personal financial management. She'll talk about setting a personal budget, and then she'll talk about your credit report. And then on Wednesday, I'll be talking about fair housing and mediation and city services. So like we say, you can watch the presentation again on the YouTube channel of the City of Springfield YouTube channel. And if you need to link to that, I will send you that by email. But thank you all for coming, and hope you stay safe and have a good evening. And thank you again, Frank.
Thank you, Nancy.
And clap.
Thank you for being here.
Okay.